Hello, members of Congress. My name is Paul J. Southwick, and I'm from Petaluma, California. I have an enduring family law case that has gone 22 years. My case started in Santa Maria, California in late 1989 when my wife abandoned me and took off with my children. The case went for 7 years in the Santa Maria courts before 4 Superior Court judges, the third one walking off the bench during a 2.5-day custody proceeding. All during that 7 years, I was accused falsely of abuse and neglect, and those allegations have never been resolved. My case was transferred to the Sonoma County courts in 1995 on a venue change 6 years after I filed the petition for separation. My ex-wife was served in another county, the County of Kings in Hanford, and I lived in Santa Maria in Santa Barbara County. I filed originally a separation, and when she responded to the summons, she did not meet the residency requirements that were mandated under state law, that being 6 months residency in the state and 3 months residency in the county, 3 months next prior, as the law states, to the county in which you respond to. After 7 long years, frustration of my visitation, illegal pendant-light child support orders, and an illegal custody decision where my ex-wife committed felony perjury on the witness stand after 3 years of custody battles where Judge Zelkanter walked off the bench where she had been pushing these allegations. She suddenly switched her story in violation of Evidence Code 621 through 623, California Evidence Code. The judge knew that there were false allegations filed. He knew that there was a false police report filed. He knew that there was a false district attorney's complaint filed, and allowed her to commit felony perjury on the witness stand. 17 and a half years later, after that proceeding, where he allowed her to have custody after absconding with the children, $10,000 worth of community property, the car, and gutted the house with furniture, I proceeded to set an order aside in the Sonoma County Superior Court. I was denied a hearing. I filed an appeal, which went to the San Francisco Appellate Court, District 1, Division 3. After nearly 16 months of fighting the State Attorney General, there were 5 of them. I represented myself in pro per. I was denied my appeal, although the court acknowledged that my due process was violated by a commissioner by the name of Louise Bales Fightmaster, who sits in the court as a temporary judge under federal incentive programs. Now, it should be noted that the state and the counties receive federal incentive programs for the enforcement of child support. Child support is considered either non-Title 4D or Title 4D. Title 4D is welfare monies. In other words, if money is expended to the child through the conduit of the mother, as noticed in the marriage of Comer, the opinion was written by Chief Justice Ronald George in the late 90s, then the state has a right under federal law to collect the monies that were expended to the child through the mother or through the custodial parent from the non-custodial parent. However, if there was fraud involved in the application process of getting those federal funds, such as Title 4A, which concerns a teenage pregnant mother, or where a father has abandoned the home, or a paternity suit, there has to be the requirement that the party qualify for those monies through the state. California does not recognize whether it's Title 4D or Title 4A or non-welfare cases. In an opinion that was written in 1976 by Evel Younger, former State Attorney General of California, he stated that when the legislature passed Civil Code 248, it required that the states enforce, the state of California enforce non-welfare as far as welfare, including non-welfare and welfare. Now, since the state did not expend any welfare monies from the federal government in my case, the state of California has pursued me after I have paid over $118,000 in child support. And now what they've done is they have taken my contractor's license, and they're in violation of federal law, Title 42, 666, Section 16, and subsection H, which requires that the county extend to the party who is risking a loss of a driver's license, of a contractor's license, a professional license, or any other license that is extended to them based upon their fitness, that they be allowed to have a procedural due process hearing, which means that the county has to first serve a notice on the party. That never happened in my case. I received a notice from the Contractors Board in October of 2011 that my contractor's license would be suspended. With it came a form that I was to fill out and send to the child support agency. Well, I did. I filled the form out. The form that came from the Contractors Board said I'm not able to appeal this matter in any way, shape, or form of the Contractors Board. So I sent my form in to the local child support agency, certified mail. I never received a response. I didn't receive a telephone call, no notice to appear, nothing came in the mail, no summons, no process, nothing. So out of exasperation, I filed a judicial review of a license review, and I got before the same commissioner again. Yep, Louise Bales Fightmaster. When I walked into the courthouse, or the courtroom, Department 20, in October of last year, 2011, the commissioner began to argue cases with me. We argued over a number of issues. I attempted to preempt her for prejudice. She refused to preempt herself. She should have recused herself under CCP 170.1, which is California law that says that if there's the appearance of any bias or prejudice, a judicial officer must recuse him or herself. She failed to do that. Right here is a copy of the clerk's transcripts in an appeal that I filed, subsequently went to an appeal, and in this is a number of documents that proves that they have been filing false documents into the record. They've been ripping stuff out of the record and putting other things in the record, omitting things that were designated on the appeal, which is the clerk's responsibility to make sure that the designation of record is correct, and basically case fixing. So what's required under Title 42, 666 is, and also Title 42, 602, 603, 608, is a periodic review of all child support orders, whether they are Title 4D or non-Title 4Ds. Whenever a state receives federal monies, federal incentive monies for collecting child support, originally it started in 1950. Title 4D was passed in 1950, and then in 1974 there was an amendment. Then in 1984 there was the Bradley Amendment, and then President Bill Clinton signed amendments after George Bush signed amendments in the 90s. Since the California courts are not having periodic reviews in non-Title 4D cases, in other words, welfare cases. What they're doing is they're allowing child support arrears to astronomically pile up. And in, I believe it is 4307 of the Family Code, there's what's known as the egregious penalty, which allows the state to add up to 72% on the arrears. But since they're not doing anything in regard to having a periodic review every 3 to 4 years, then it's easy to see that in a number of cases that are non-welfare cases where the state collects 90 cents on the dollar, and that came out of Turner v. Rogers, which the U.S. Supreme Court determined in 2010, amicus curiae brief was filed by the Attorney General of the United States. In that amicus curiae brief, the Attorney General cites 90 cents on the dollar for every dollar they collect in child support cases. So since California draws no distinction between welfare and non-welfare cases, you can see why they're not having the reviews. The reviews, in other words, if an arrearage is $5,000 and it's never reviewed and the case goes 20 years, that $5,000 can easily wind up being $95,000 or $100,000. Mind you, no welfare money's been expended in a non-welfare case. So after the children reach the age of majority, which is 18 in the state of California, the county comes back and says, oh, by the way, Mr. Jones, Mr. Smith, Mr. Southwick, you now owe $100,000. And if you don't pay it, we're going to take your license. We're not going to give you a hearing, not going to give you a chance to challenge whether or not the order is good. We're just going to collect that money from you until you're 80 or 90 years old. At the same time, what they're not telling you is we're going to rip off Congress. We're going to rip off the Treasury. We're going to rip off every governmental agency that gives us money because we're going to double dip. So instead of having the periodic reviews and putting the arrearage amount on a valid assessment onto the monthly payment so that the balance declines, it's skyrocketing, going way up so that the counties can get billions of dollars of federal money. That's why I'm here today. I'm here to bring this to Congress's attention that the states are not doing what Congress originally intended to do. On September the 11th, I filed this opening brief in a second appeal after I had gone to the United States Supreme Court in 2009 with a writ of certiorari on the first deprivation of due process. Now I'm back in the appellate court. This is 5 years of research. There are over 60 state cases, most of them Supreme Court cases that I cite, over 22 U.S. Supreme Court cases and 5 federal cases, wherein the state of California is supposed to abide by these cases, yet they're doing nothing. They gave me no hearing. They proceeded ultra vires in the absence of jurisdiction because of what's known as the doctrine of the exhaustion of administrative remedies. They're violating the Administrative Procedures Act. 17520 is California's take the license law. It has 63 subsections. At the end of the statute, it says, the legislature finds that if any portion of the law is found to be unconstitutional, that the remaining portions survive. That's called a severability clause. But the last section says that any administrative hearing that is applied to an applicant for a license, and a license comes under police power to engage in a trade, profession, business, I don't care whether it's dog grooming or whether it's being a painter or a roofer or a pool service person. That license is based upon fitness. First, you qualify for the license, and then after so many years, you're vested. In other words, that license becomes your personal property. And that's what the U.S. Supreme Court said in a case called Bell v. Burson, and the state Supreme Court, California, said in Rios v. Cousins. Well, what's going on in Sonoma County and in 57 other counties of the state is this. If a person has a child support order, whether it's arrears or whether it's current support, a caseworker pushes a button and all of a sudden your license is suspended. No hearing, no notice, no summons, nothing. That's contrary to what the United States federal law says at Title 42, 666. First, they're supposed to put you on notice. That's called notice and the opportunity to be heard. And in 1950, the U.S. Supreme Court heard a case called Mullane versus Central Hanover Bank. And in that case, they said, the essence of due process is notice and the opportunity to be heard. Then years later, the U.S. Supreme Court said in a case called Armstrong v. Manzo, that the opportunity to be heard must be meaningful at a meaningful time and in a meaningful place and in a meaningful manner. Well, what the California legislature has done in 17-520 is they have bifurcated the notice portion from the opportunity to be heard portion. In other words, you get your notice from the licensing agency based on 30 days, and then you get your opportunity, supposedly, at the child support agency, who's receiving money now. Remember, that's a pecuniary interest. But when you send your form in, they never respond. So that's the basis of my appeal here, is that the child support agency, in my case, then they know that the judgment is void on its face because in August of 2011, I sent them a common law cease and desist. And that common law cease and desist is right here in this clerk's transcript, and it cites over 52 U.S. Supreme Court cases where the county and the state were stopped from doing what they were doing, but they didn't pay any attention to it and they didn't respond to it. So they defaulted. So did my ex-wife. When I filed my motion to get in front of the court, they didn't respond to the motion either. So once again, when I got in front of Commissioner Fightmaster, she started arguing case law. Oh, that case is no good. This case is no good. We did this and we did that. Talking with an attorney from the child support agency by the name of Susan Silverek. And the reason I point out who their names are is because they're all guilty of crimes. And the crime is this, that they are working together in collusion to rip off the federal government, to rip off individuals and not protect the due process rights of those people coming before them. Every day in California, those who are made subject to 17-520, California's take the license law, have to run the gauntlet without the benefit of counsel. They're not put on notice. They have no opportunity to be heard. They are just shuttled into the court and forced to sign a paper, a stipulation. And what that stipulation is, it is nothing more than a conditional acceptance contract. And then once you sign it, they say, oh, I'm sorry, you stipulated, you waived your rights to appeal. So when a pro per goes into the state appellate court, they say, oh, well, you stipulated, so you didn't need to have a hearing. But mind you, you were never put on notice. And even if you were served a form like this from the California Contractors Board, see up here, I served it by certified mail. I sent this to the child support agency, and you don't get any response back from them. So I don't know how in the world that could be notice and the opportunity to be heard. Meanwhile, the county, through the State Department of Health and Human Services and the Department of Child Support Services in Sacramento, which heads up 15 different agencies. If you go to their website, you'll find that they're proud of the fact that they are layered at the top of 15 different governmental agencies, all of which are getting federal money. So since you don't get the hearing, you don't get an appeal. You don't get an appeal, you don't get any justice. Now, I showed this to Mr. Windsor before I came here and sat down in this chair to be interviewed. There's a case called Worst v. Worst. This is in July 9 of 1942. And in that opinion, the appellate court said these words, and I'll read them to you. The means by which appellant was compelled to abdicate the rightful exercise of his or her historic right to appeal constituted an excessive power by the court, and the jurisdiction of the court was thereby overreached. As a consequence thereof, a judgment was rendered if the allegations of the complaint be true, and we must, as the trial court should, in passing upon a demurrer to a pleading, assume the verity thereof, that means truthfulness, with reference to the division of the community property that was of no force or effect, because the means adopted to compel plaintiff's acquiescence in that portion of the judgment affecting the disposition of the community property transgressed the fundamental right guaranteed every litigant in a court of justice to appeal from a judgment affecting his liberty or his property. I want to stop right there. Parental rights are constitutionally protected liberty interests. The United States Supreme Court has said for over 90 years that the right to a parent and to the access of his child to have a close and continuing relationship has been constantly reaffirmed, beginning with a case called Meyer v. Nebraska, Pierce v. Society of Sisters, and the latest landmark decision was Troxel v. Granville. Since the United States Supreme Court has said this and laid this down, California rushes to get custody support orders in place called pendant-like custody orders, so they can hope that maybe the mother, who typically has gotten custody throughout the years in California, the last 60 to 70 years, that she'll run down to the county and open a case so they can get money from the federal government, hoping that the arrears will pile up if someone loses their job, or they can force them into a conditional acceptance contract by making them sign a stipulation where they're going to lose their driver's license. Members of Congress, there are millions of people affected by this, and the counties are doing nothing about it. They're not following the federal law. I point to that in my brief. Mind you, I spent 5 years writing this. Let me further read what it says in Worst v. Worst. Any departure from those recognized and established requirements of law, however close apparent adherence to mere form in method of procedure, which has the effect to deprive one of a constitutional right, is as much an exercise of jurisdiction as where there exists an inceptive lack of power. That's jurisdiction. The courts, in my case, proceeded ultra vires and have proceeded ultra vires for more than 22 years. Now, in 2009, when I filed my first appeal, I had already filed one of these green documents called an opening brief. A case came down by the name of Robert J. versus Catherine D. I went through the appellate court, 4th District in San Diego. In that case, the appellate court said this, and of course it was approved by the Supreme Court of California because California Supreme Court approves all published cases, that when allegations of abuse and neglect arise in a child custody proceeding, that is the duty of the court, in other words, a mandatory duty of the court, to stop the proceedings in the best interest of the children and have what's known as a veracity hearing, leading to the truthfulness of those allegations. If it doesn't, it exceeds the power granted to it. In other words, it acts in excess of jurisdiction. And any order derived from an in excess of jurisdiction is a void order. It's a nullity. That was said as early as Elliott v. Pearsall in 1828. Now you may wonder why I know all these cases by heart. I'm not reading a script, they're coming out of my mind. The reason is I've been forced to study them. I've been forced to go it alone. My second attorney abandoned me. My first attorney didn't do what he was supposed to do. That was 22 years ago. And every time I go to court, oh, we're not going to hear you. We're not going to give you an opportunity to present your facts, to present your evidence, even if you did file a common law cease and desist based on 52 U.S. Supreme Court cases where the county didn't respond or the mother didn't respond, who the county is shielding because in the marriage of Comer, once again I mentioned that case earlier, the Supreme Court of California said the county steps into the shoes of the obligee parent, in other words, the custodial parent, but it's a chosen action. And what that means is that when they step into a parent's shoes, they have to accept the liability that they committed prior to the registration of the order. In my case, that was in 1992. The felony perjury that occurred after she switched her story happened in 1991. The allegations began in early 1990. My children have been kept from me. My daughter is estranged to me for over 22 years, a perpetual mind poisoning. And this is really important because a child has a right to have a relationship with a parent. A child has a right to be free of an allegation of abuse or neglect. In the early 70s, Congress passed what's known as the Mondale Act. The Mondale Act allowed small sums of federal money, it's again federal money, to the states if they would adopt laws that would protect children from physical abuse, mental abuse, psychological abuse, and the worst, sexual abuse. But California has not done anything about the psychological abuse portion. And it wasn't until 2009 and the published case of Robert J. versus Catherine D. that they first said that the court, as a requirement under the best interest of the children, again going back to the U.S. Supreme Court case of Meyer v. Nebraska, 1925, that said that's where the best interest of the children doctrine emanates from, that they must get to the bottom of that allegation before they proceed to the custody decision. That's not happening in many cases still today. And in the courts in Sonoma, there's a number of other cases, and we're fighting this issue because the courts don't want to accept the fact that a stare decisis decision that was issued by the 4th District in 2009 and decisions made by the U.S. Supreme Court hold sway. In other words, they're thumbing their nose at the United States Supreme Court and the 9 justices and the 9th District Federal Court that has laid down laws based on the doctrine of stare decisis, and numerous cases which I cite here. Over 60 cases in my table of contents alone in California, most of them Supreme Court cases that are high holding cases. They're ignoring them all. And the reason they're ignoring them all is because they want that federal donut. They want that money coming into the state because in 17600 of the Family Code, the legislative analyst said, child support arrearages represent a substantial increase to the state budget. So it can clearly be seen that this is a money issue, and it is only about money. It's not about the best interests of the children. It's about the best interests of the state and how they can rip off Congress and how they can rip off the American taxpayer and the United States Treasury. And I'm asking Congress today to do something about this, to enact what I call the Child Support Reform Act that will mandate to every county and every state in this United States a mandatory hearing to make sure that those arrearages do not climb. because in states like Texas and Louisiana and in Virginia and Pennsylvania, arrearages are skyrocketing because the states are broke. So they're using the federal payout window as a rag doll and abusing the child of federal payments. Thank you very much.